Hello, I'm David R. Schneider. I'd like to welcome you back to our series of informative videos on different estate planning topics. This particular topic will talk about something called a children's trust, managing a plan for minor or immature children, and we'll also discuss guardianship proceedings. When utilizing our revocable living trust, one of the things that we have to do is prepare for minor or immature beneficiaries. When we talk about leaving property to our children or to our grandchildren, we want to make certain that our trustees in our living trust are not just throwing money at a problem. The state of California says that your child or your grandchild is mature at the age of 18. At the age of 18, they're allowed to vote for president. They're allowed to carry an M16 rifle and go die in a foreign land. Heck, and in most places, they're still allowed to buy cigarettes. 3 things that an 18-year-old should not be doing. Let alone should we be handing your 18-year-old $500,000 in cash. Typically a bad idea, or a good idea for the Ferrari store. What we want to do is make certain that our children are protected from the point when they reach an adulthood to the point when they are adults and yet a bit more mature. What we will utilize is something called a children's trust. The children's trust is designed to allow the trustee to administer those assets in the best interest of the children, the best interest of the beneficiaries, and utilize that money, the beneficiaries share, unlimited for their health care needs, their educational needs, and their welfare needs. Now, health care can be anything from eyeglasses to a hernia, including health insurance. Education, private school, secondary school, college, master's plan, technical trade school. Any type of educational program qualifies under a definition of education. And welfare. Welfare typically defined as their custom manner of living, roof over their head, shirt on their back, food in their mouth. We establish the children's trust so our trustee can use those monies for their benefit off the top up to the whole if necessary. For many families, we're going to find that they've actually, through their hard work, through the equity in their home, or through their life insurance and retirement accounts, have more money than is necessary to meet those goals for the children. So we have to find a way to distribute those assets to the children. I went to the school that says maturity comes not just from age, but also from life's experiences. So we might establish a plan that holds the money back to a time when they are a little bit more mature, not just the state's requisite of 18. We might have a plan that delivers the money to the children, perhaps let's say 10% when they turn 21, 20% when they graduate from college, 30% when they turn 27, balance when they're 30. We can tailor a plan that fits your family's needs based on the types of assets that we expect to have and the nature and the knowledge that you have about your own children. You're probably the best to decide when this is going to happen, not just letting it fall to chance. An area of confusion that often comes up is in dealing with minor children. We're very, very concerned as parents. I am a parent as well. What happens with our minor children? We all have an idea about what should happen, where our children should go, who should take care of our children. Well, we need to express these ideas in what's called a nomination of guardian. There are 2 types of guardian. There's a guardian of the estate and a guardian of the person. The guardian of the estate is going to be there to manage the children's money, just the same as you do now for your child if you've developed, let's say, a bank account, a savings account. You serve as the custodian and it is your child's money. Well, we need an adult figure, somebody over the age of 18, but is mature enough to make these decisions, to step in and take control as guardian of the estate. The guardian of the person actually steps into your shoes as the surrogate parent, making personal decisions for our under 18-year-old. decisions like where the child will live, where the child will go to school, healthcare decisions, advanced educational decisions, social decisions, reward them, punish them, all the same things that you do as a parent. This is called the guardian of the person. Now, unfortunately, the parent does not get the full right to dictate who will be the guardian. This is a nomination process which must always be approved by the probate court. Now, this is not a probate proceeding, and yet it is a procedure before the probate court. The court is obligated to act in the best interest of the child at all times. This means that the court will investigate the persons who are nominated to become the guardian, and provided that this person passes such an investigation, then the court will award those persons as the guardian. If there are competing petitions, then the court has to make a determination, again, based on what is in the best interests of the child. Competing guardianship petitions might involve people more local versus people less local. It might involve persons that are blood related and persons that are not blood related. Each case is unique before the probate court, and again, the court focuses on what is in the best interest of the child. We want to use your opinion and put your opinion before the court, because who would know better what's in the best interest of the children than the parents? But it's a time when you cannot otherwise be there. You can't be there because you've passed away or you've become incapacitated, so we utilize your voice through the nomination of guardian. If you would like more information about this topic or any of the topics in our series of videos, or to book a free no-obligation consultation with me, please give our office a call, David R. Schneider, 805-374-8777, or please visit our website at drs-law.com.